3201, the state of Ohio versus Nicholas George. Mr. George is before the court with his counsel, Ms. Diefenbach, Ms. Tranter, on behalf of the state of Ohio. Ms. Tranter.
Your Honor, my understanding is that Mr. George is prepared to change his plea this morning. He's going to enter a guilty plea to the one count of the indictment, theft of felony with 5th degree. We're going to ask for a pre-sentence investigation and continue the case for sentencing. There will be a request for restitution in this case. $1,250 will be requested for the Mason Probation Department.
Ms. Diefenbach, is that accurate?
Yes, sir.
Mr. George, you're telling me you're going to change your plea to guilty to the one count of theft from the indictment. Before we get to your change of plea, I am required to go over some things with you. Okay, sir?
Okay.
How old are you?
29.
How far did you go in school?
I graduated.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, I am.
Has anyone promised you how the court would sentence you in this case?
No, they have not.
Has anyone threatened you in any way to get you to plead guilty against your will?
Nope.
Are you satisfied with the representation you've received from Ms. Diefenbach?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
Nope.
Do you take medication that interferes with your ability to understand what's going on today?
No, I do not.
I have in front of me a document called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, I did.
Did you read this and go over it with your attorney before you signed it?
Yes, I did.
And you believe you understand what it says?
Yes, sir.
This document says you're running a plea of guilty to one count of theft as a felony of the 5th degree that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The prison term is not mandatory. Do you understand the maximum penalties?
Yes, I do.
You're also subject to a discretionary period of post-release control, which means if you are sent to prison upon your release, the adult parole authority may choose to supervise you for up to 2 years. If you violate those rules of supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever's longer, and that time would run consecutive to any additional prison time you get sentenced to. Do you understand that?
Yes, I do.
But it's not mandatory that you're sent to prison. The court does have discretion to place you into community control, what some refer to as probation. While on community control, you will have rules you must follow as well. If you fail to follow those rules, this court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, I do.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, I do.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, I do.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, I do.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yep. Yes,
The
sir.
standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of the charge from the indictment. Do you understand that?
Yes.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, I do.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you will be waiving all these rights? We will not have a trial.
Yes.
This is how you want to proceed.
Yes, I do, Honor.
All right, Ms. Tranter.
Your Honor, this occurred on or about the 14th day of October, 2025, Warren County, State of Ohio. On that date, Nicholas George did with purpose to deprive the owner of property, knowingly obtained or exerted control over the property without or beyond the scope of, without their consent or beyond the scope of the consent that was implied. Your Honor, this is a situation where Mr. George had been issued a TAD monitor by the Mason Municipal Court. The monitor became unreadable, later to be found that he had tampered with it and cut the monitor. the replacement cost of the missing equipment, which was not recovered, $1,250.
Okay, Ms. Diefenbach, anything on those facts?
No, sir.
Mr. George, did you hear the statement that she read?
Yes, Your Honor.
Do you acknowledge and admit that what she said is true?
Yes, Your Honor.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed?
Yes, I do.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I will order a pre-sentence investigation. We'll come back in a few weeks and do sentencing at that time. How much longer are you serving on your sentence from Mason?
I just have 10 days left, Your Honor. They gave me 60 originally.
If someone from court services does not get the opportunity to come over within the next 10 days to visit you,
Mhm.
do you know where court services is in this building?
I'm sure I could find it once I walk in. I could probably ask for help.
I'm just letting you know that it's your responsibility because you're under an OR bond here
Mhm.
with pretrial supervision.
I did want to say I have a probation. Because of this charge, I violated my probation in Butler County. So I do have a holder from them. So I'll be going straight to Butler County from here. So I won't be able to physically.
Okay, well, that's good to know. I'm going to hopefully let the court services know. Oh, hang on one second. Hopefully someone will be over within the next 10 days before you leave our jail, to get this process started. But I'm just telling you,
Okay.
if not, it's your responsibility to make sure you get over here to schedule your interview and assessment, okay?
Yeah, that's not a problem. I'm pretty sure they're going to put me back on probation anyway. It's my first violation there. I'll just drive up here afterwards if not.
Okay, all right, just so you know. All right, anything else,
No, Your Honor, thank you.
Ms. Diefenbach?
No, sir.
All right, thank you all.
Thank you.
Thanks, Your Honor.
Thank
Okay.
you.
Now, who's that?
That's me.
Okay, give me an alternative. Like your mother or something.
No,
Will do.
no, just for our purposes, just put,
Okay.
you have to be held in the jail. Well,
Do they have a holder, if you put release, and that holder would trigger for them, right?
he's still serving time for Mason, so he's got that plus Butler
Okay.
County. Yeah, I guess we could just release him.
Yeah, because he's not being held for
We're not
us.
being, he's not being held on this case at all. He's on an OR bond.
I mean, we don't even need like a,
Yeah.
Yeah, he's in an OR.
And if they release him for they won't because it'll just go to Butler County. But he's
Yeah.
still serving a Mason case, so they can't. I don't know. I would say just put in the commitment that release him.
Okay.
Yeah.
If you want.